Let's take a look at statements made by employees as part of the selection process from an employment law perspective. Employers are not the only ones who have to watch what they say. There are potential legal consequences for applicants who provide prospective employers with false information or omit important facts in hopes of enhancing their chances of getting hired. First, in cases where employers have to defend their decisions not to hire, such as discrimination claims, court regards refusals to hire due to falsification or omission as a legitimate non-discriminatory reason for not hiring. This is particularly true when the employer has a consistently enforced policy to this effect. The employer notifies the employee of it, usually in the application form, and the falsification or omission is material rather than trivial. Likewise, employers that discover a falsification or an omission after a person has already been hired and then discharge the person will generally be able to defend any wrongful discharge claim that arises out of termination. Employers should have a policy requiring that candidates provide complete and truthful information and specifying that the penalty for failing to do so will be either refusal to hire or termination if the omission is discovered post-hire. Cases involving after acquired evidence demonstrate another consequence of a candidate's falsification during the hiring process. The legal remedies available to employees in suits against their employers may be limited because of them. For example, suppose a job candidate falsely claims to have a college degree and is hired. Subsequently, she suffers harassment on the job and files a sex discrimination suit. In preparing to defend itself, the company goes over all of its records pertaining to this employee, and during the discovery process leading up to litigation, the employee is forced to admit that she fabricated the information. Pursuant to company policy, she is then officially terminated for providing false information on her application. Thus, the employer acquired evidence of previous wrongdoing, but only after the employee was discriminated against and filed suit. Should the prior wrongdoing of the employee negate her ability to sue the employer? After all, had the employer known about the false information she submitted, it might not have hired her in the first place. The Supreme Court has held that employees do not lose their ability to bring suit simply because they do not have entirely clean hands. Lawsuits serve not only to remedy harm to individual plaintiffs, but also to uphold public policy. However, if the employer can show that it would not have hired the employee had it been aware of the falsification, her remedies will generally be limited to the point in time when the wrongdoing was discovered. Not all instances of alleged falsification of an application will be treated as after acquired evidence in cases.